माननीय राज्यपाल महोदय, कार्यक्रम आरंभ करने के लिए क्या मुझे आपकी अनुमति है? महोदय, मंत्रीगण अपने पद तथा गोपनीयता की शपथ ग्रहण करने के लिए यहाँ उपस्थित हैं। निवेदन है कि कृपया मंत्रीगणों को पद एवं गोपनीयता की शपथ ग्रहण कराएं। श्री गजेंद्र यादव।
मैं गजेंद्र बिसराराम यादव ईश्वर की शपथ लेता हूं कि मैं विधि द्वारा स्थापित भारत के संविधान के प्रति सच्ची श्रद्धा और निष्ठा रखूंगा। मैं भारत की प्रभुता और अखंडता अक्षुण्ण रखूंगा। मैं छत्तीसगढ़ राज्य के मंत्री के रूप में अपने कर्तव्यों का श्रद्धापूर्वक और शुद्ध अंतःकरण से निर्वहन करूंगा तथा मैं भय या पक्षपात, अनुराग या द्वेष के बिना सभी प्रकार के लोगों के प्रति संविधान और विधि के अनुसार न्याय करूंगा। मैं गजेंद्र बिसराराम यादव ईश्वर की शपथ लेता हूं कि जो विषय छत्तीसगढ़ राज्य के मंत्री के रूप में मेरे विचार के लिए लाया जाएगा अथवा मुझे ज्ञात होगा उसे किसी व्यक्ति या व्यक्तियों के तब के सिवाय, जबकि ऐसे मंत्री के रूप में अपने कर्तव्यों एवं सम्यक निर्वहन के लिए ऐसा करना अपेक्षित हो, मैं प्रत्यक्ष अथवा अप्रत्यक्ष रूप से संसूचित या प्रकट नहीं करूंगा।
श्री गुरु खुशवंत साहेब।
मैं गुरु खुशवंत साहेब सत्य निष्ठा से प्रतिज्ञा करता हूं कि मैं विधि द्वारा स्थापित भारत के संविधान के प्रति सच्ची श्रद्धा और निष्ठा रखूंगा। मैं भारत की प्रभुता और अखंडता अक्षुण्ण रखूंगा। मैं छत्तीसगढ़ राज्य के मंत्री के रूप में अपने कर्तव्यों का श्रद्धापूर्वक और शुद्ध अंतःकरण से निर्वहन करूंगा तथा मैं भय या पक्षपात, अनुराग या द्वेष के बिना सभी प्रकार के लोगों के प्रति संविधान और विधि के अनुसार न्याय करूंगा। मैं गुरु खुशवंत साहेब सत्य निष्ठा से प्रतिज्ञान करता हूं कि जो विषय छत्तीसगढ़ राज्य के मंत्री के रूप में मेरे विचार के लिए लाया जाएगा अथवा मुझे ज्ञात होगा उसे किसी व्यक्ति या व्यक्तियों को तब के सिवाय, जबकि ऐसे मंत्री के रूप में अपने कर्तव्यों के सम्यक निर्वहन के लिए ऐसा करना अपेक्षित हो, मैं प्रत्यक्ष अथवा अप्रत्यक्ष रूप से संसूचित या प्रकट नहीं करूंगा।
श्री राजेश अग्रवाल।
मैं राजेश अग्रवाल ईश्वर की शपथ लेता हूं कि मैं विधि द्वारा स्थापित भारत के संविधान के प्रति सच्ची श्रद्धा और निष्ठा रखूंगा। मैं भारत की प्रभुता और अखंडता अक्षुण्ण रखूंगा। मैं छत्तीसगढ़ राज्य के मंत्री के रूप में अपने कर्तव्यों का श्रद्धापूर्वक और शुद्ध अंतःकरण से निर्वहन करूंगा तथा मैं भय या पक्षपात, अनुराग या द्वेष के बिना सभी प्रकार के लोगों के प्रति संविधान और विधि के अनुसार न्याय करूंगा। मैं राजेश अग्रवाल ईश्वर की शपथ लेता हूं कि जो विषय छत्तीसगढ़ राज्य के मंत्री के रूप में मेरे विचार के लिए लाया जाएगा अथवा मुझे ज्ञात होगा, उसे किसी व्यक्ति या व्यक्तियों को तब के सिवाय जबकि ऐसे मंत्री के रूप में अपने कर्तव्यों के सम्यक निर्वहन के लिए ऐसा करना अपेक्षित हो, मैं प्रत्यक्ष अथवा अप्रत्यक्ष रूप से संसूचित या प्रकट नहीं करूंगा।
माननीय राज्यपाल महोदय, आज की कार्यवाही समाप्त घोषित करने के लिए क्या आपकी अनुमति है? महोदय, आज का कार्यक्रम समाप्त हुआ।
आप सभी से आग्रह, छत्तीसगढ़ मंडपम के प्रांगण में आप सभी के लिए स्वल्पाहार की व्यवस्था है। हम निवेदन करते हैं, कृपया आप सभी स्वल्पाहार ग्रहण करने का कष्ट करेंगे।
You can continue and we'll note down the point.
No, kindly, my lord, give me only 15 minutes.
Justice Narasimha and Justice Vikramnath, they don't require physical copies.
Have it in the shop. मेरा पास भी होगा। आपका पास भी होगा।
Yes.
Article 111 now.
111, 155.
55.
I have completed 111.
Yes, complete.
I have completed 74. My lords would find it at page 128.
Yes.
Lord, this is appointment of the governor, and this would, I'm sorry. But this would have tremendous bearing for your lordship's consideration, because Lord, the concept which is going on, that the
ये रखिए।
What is the significance and sanctity attached to the office of the governor? Lord, that we come to know from the Constituent Assembly debates. Lord, it's not, my Lord, an asylum for retired politicians, as, my Lord, we understand. It has its own sanctity. And, my Lord, the framers of the Constitution have debated on it, that why we need governor, why we need governors with the powers which we are going to confer upon it, and in the federalism which we have adopted, as against, my Lord, the absolute federalism in United States, where each state or province has its own constitution, has its own Supreme Court, has its own, my Lord, way of governance. We have not adopted that.
Even dual citizenship.
The dual citizenship. So, my Lord, they have examined that center will have to play a role in the governance of the provinces, which is now states, and that is how, my Lord, the position of governor is conceived. Lord, please have a look at page 128. Lord, section 46 is the peri materia provision, or, my Lord, if I may say, the precursor to the present 155, where the governors were appointed. Lord, page 128 bottom, Government of Bengal, Madras and Bombay. The presidencies of Fort William in Bengal, Fort St. George and Bombay are subject to the provisions of this act, governed by the governors in council of those presidencies respectively, and the two former presidencies are in this act referred to as the presidencies of Bengal and Madras. Then, my Lord, comes 35 Act. Lord, initially the idea was that the governor should also be an elected person, so that he also wields the same democratic sanctity, and which is rejected by the framers of the Constitution. I'll show that, my Lord. Section 48, Lord, 1935 Act, again, my Lord, the Colonial Era Act. The governor of a province is appointed by His Majesty by a commission under the Royal Sign Manual. The provisions of the third schedule to, my Lord, not relevant. Now, my Lord, draft constitution, my Lord, which was prepared by Mr. Rao, the governor of a province shall be elected by direct vote of all persons who have the right to vote at a general election for the legislative assembly of the province. My Lord, Dr. Rao introduced the concept of governor being an elected person. Then, my Lord, the drafting committee chaired by Dr. Ambedkar ji, my Lord, made this. Again, my Lord, provided for election. The governor of a state shall be elected by direct vote of all persons who have the right to vote at a general election for the legislative assembly in the state. So his election would be confined to that particular state. Then, my Lord, the drafting committee gives a second option for consideration. An alternative is given. That is, my Lord, this. The governor of the state shall be appointed by the president by warrant under his hand and seal from a panel of 4 candidates to be elected by the members of legislative assembly of the state, or where there is a legislative council in the state, by all the members of legislative assembly and of the legislative council of the state assembled at a joint meeting in accordance with the system of proportionate representation by means of single transferable vote, and the voting at such election shall be by secret ballot. So they were visionaries. They gave 2 options, appointment or election. Appointment, my Lord, again by indirect way of election only. Now, my Lord, please see the debate. My Lord, at page 130 it starts. The Honorable President says, as regards this, honorable members will see that there are 2 alternatives suggested by the drafting committee. The amendments are referring to either the one or the other alternative. So I think the best way is to take an amendment in favor of one of the alternatives, and if then is accepted, then all other amendments relating to the alternative drop automatically. We take 2006, and this is, and if this is carried, then we go to the second. 2006 is the number of that amendment.
Number of them.
Yes. Then, my Lord, Ghanshyam Singh Gupta. Sir, I suggest this. The amendments, of course, may be taken But first, we might form our opinion as to whether we want the first or second alternative, so that if we want the first alternative, then the amendment it would come, my lord, in kindly bear with. Then, my lord, Sri Brajeshwar Prasad, my lord, this is important. For my lord, he suggests that for Article 131, the following be substituted: Governor of a state shall be appointed by the President by warrant under his hand and seal. He said no election, whether as per alternative 1 or alternative 2. And the reason or the justification, my lord, he places before the assembly. The great merit of this amendment, which stands in the name of the 5 or 6 members of this house, is that it lays down a simpler procedure than the prescribed either in the article or in the alternative suggested by the drafting committee. I feel, sir, that in the interest of all India unity and with a view to encouraging centripetal tendencies, my lord, that is a tendency, my lord, to my lord,
Stronger.
unification,
Stronger center.
the strong cohesion, my lord, if I have used policies, tendencies, it is necessary that the authority of the government of India should be maintained intact over the provinces. To say that the president may nominate from a panel of names really means restricting the choice of president. It gives power into the hands of the legislature. It is necessary, sir, that the president should be free from the influence of the legislator. I feel that the governor may be one from the province or from another province. Personally, I feel that the man from a province should not be appointed in the same province because it gives encouragement for vociferous tendencies. So, my lord, that tendencies, my lord, internal fiction, etc., etc. So I say that choice of the president should be unrestricted and unfettered. Sir, I have nothing more to add. This is a simple proposition and I commend it for acceptance of the House. Then Alladi Krishna Swami Iyer. Sir, in view of the decision that was reached some 2 years ago and in view of the fact that I feel convinced that only right course, taking all the circumstances into consideration, is to accept the amendment of Mr. Brajeshwar Prasad. I should like to say a few words in support of the amendment. In the consideration of this question, the main points to be remembered are that this assembly has accepted the introduction of responsible government and the real executive power had been vested in ministry responsible to the lower house in the different states. No dispute or difficulty. The real power vests in the elected people who are elected by the legislators, by the people of that state as legislators. The question for consideration before this House is whether, under these circumstances, there is any point in going through an expensive and elaborate machinery of election based upon universal suffrage. After giving my best consideration to the various proposals put forward: 1. Of choice of governor on the basis of universal suffrage; 2. change would be desirable. This was the flexibility of Sardar Patel, my lord. He chaired the provincial committee, took a particular view, and thereafter takes the holistic view and say that some change is desirable. Now, the reasons for this have been stated before the House, and I need not go into them, except to say that I myself originally was not very definite, if I may say so, in my mind as to which would be the preferable course. I preferred something, but not to the extent of considering it as absolutely necessary. But the more I thought about it, the more I conferred with others and discussed with them, the more I felt that from almost every point of view, this proposal that is moved of a nominated governor in the present context of the Constitution was not only desirable from practical point of view, but from democratic point of view, too, it was desirable and worthwhile. My lord, now I can skip that, my lord, and kindly come to the bold part. My lord, I have, this is the way, my lord, I generally make it bold so that the relevant part is before your lordships, but we don't consume your lordships' time in reading them. And I must tell your lordships, my lord, I have selected passages from the Constituent Assembly debates which are relevant according to me for deciding this issue by your lordships. There are other debates also on these subjects. Entire debate is placed in volume 4. If your lordships would like to, 4.2, my lord, if your lordships would like to go through it. But these are the relevant debates, my lord, from the standpoint of the issues which your lordships are advising us, my lord. But on the whole, it probably would be desirable to have people from outside, eminent people, sometimes people who not probably like a more active domain for their activities, but there may be an eminent education or persons eminent in other walks of life who would naturally, while cooperating with government and carrying out the policy of the government, at any rate helping in every way so that the policy might be carried out, he would themselves represent before the public someone slightly above the party and thereby, in fact, help that government more than if he was considered as a part of the party machine. I do submit that there is really a more democratic procedure than the other procedure, in the sense that the latter would not make the democratic machine work smoothly. Then, Dr. Amalot. Yes. My lord, the first part of the Dr. Ambedkar ji is only, my lord, the description or a paraphrasing of what has happened. The second part would be relevant, my lord. Well, that power, your lordship gets, my lord. That power an elected or a nominated governor will have, if he happens to call the wrong person to form a ministry, he will soon find to his cost that he has made a wrong choice. That is not a thing that could be avoided by having an elected governor. Such a governor may have a friend of his choice whom he can call in to form the ministry, and that issue can be settled by the House itself by a motion of no confidence or confidence. But that is not the aspect of the question which is material. The aspect of the question which is material is the governor going to have any power of interference in the working of a ministry which is composed of a majority in local legislature? If that governor has no power of interference in the internal administration of a ministry which has a majority, then it seems to me that the question whether he is nominated or elected is wholly immaterial. That is the way I look at it. And I want to tell the House that in coming to their decision, they should not bother them more or less academic question whether governor has to be nominated or to be elected. They should bear in mind this question: what are the powers which the governor is going to be endowed? That matter, I submit, is not before us today. We shall take it up at a later stage when we come to question of Article 175 and 188. Please note there, my lord, in your lordship's note, 175 is the draft article, which is Article 200 today. And 188 is emergency powers, my lord, which are not, which we are not
concerned at this stage.
No, not concerned. And probably by amendment or the addition of some other clauses which would give him powers. The House should be careful and watchful of these new sections that will be placed before them at a later stage. But today it seems to me, if the Constitution remains in principle the same as we intend that it should be, the governor should be a purely constitutional governor with not power of interference in the administration of the province, then it seems to me quite immaterial whether he is nominated or elected. Now, my lord, what is accepted is 131 draft article. The governor of the state shall be appointed by the president by warrant under his hand and seal. My lord, both the alternatives were given up, and
third.
Vijeshwar Prasad's amendment that he should be appointed by the president, nothing more, nothing less, should be there. So far as his powers are concerned, we will consider when we consider present article 200, and I'll be able to show that this wish, desire, and Lord, what was in mind of the constitutional framers did reflect in Article 200, that he would have only those powers which are conferred and nothing more, maintaining supremacy of the elected wing. My lord, I'll come to that. My lord, please. Now, my lord, come to next page, Article 163. Page 134, Article 163. My lord, it is in pink color.
Yes.
Your lordship gets one. My lord, this green color final draft of the Constitution is, my lord, same, which I have read, my lord, therefore I am not reading it. The color is, my lord, there is some legend, my lord, green is the final thing, etc. At my age, my lord, I can be colorful only on paper.
We agree to disagree.
He's not telling you the entire truth.
No, but that's what I said. We agree to disagree.
Yes. Lord, 163. Lord, what was 1919 Act? Lord, I have quoted, but what is bold is, my lord, relevant for the present purpose. For completeness, I have quoted this whole. 3. In relation to transferred subjects. My lord, when the assembly talks about transferred subjects, it means subjects allotted to state. List 2. 7 schedule list 2. Present. The entries may have changed, but transferred subject would mean the state list, where legislature has the power or competence to legislate. In relation to transferred subjects, the governor shall be guided by the advice of his ministers, unless he sees sufficient cause to dissent from their opinion, in which case he may require action to be taken otherwise than in accordance with that advice, provided that rules may be made under the principal act or the temporary administration of a transferred subject where, in case of emergency, owing to a vacancy, there is no minister in charge of the subject by such authority and such manner as may be prescribed by the rules. Then kindly come to, my lord, what was suggested, what was in 1935. My lord, something similar, but please see 50 subsection 2. I'll read, my lord, one also, because here the governor's discretion comes. But your lordships have seen yesterday, the president is not left with any discretion. 19 Act till Article 111 as it stands today. 75, which it stands today. 111 is a power of assent. But appointment is solely guided by the aid and advice of the Council of Ministers. In case of governor, my lord, the situation was different. The discretion continued throughout, but the discretion came to be circumscribed by use of words which were very consciously used. Lord, please see Council of Ministers in 1935. There shall be a council of ministers to aid, counsel of, and advise the governor in the exercise of his functions. Ministers, except in so far as he is by or under this act required to exercise his functions, or any of them in his discretion, provided that nothing in this subsection shall be constrained as preventing the governor from exercising his individual judgment in any case, whether whereby or under this act he is required to do so. The governor in his discretion, please see the Malord, may preside at the meeting of Council of Ministers if any question arises whether any matter is or is not a matter as respects which the governor is by or under this act required to act in his discretion or to exercise his individual judgment. The decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion or ought not to have exercised his individual judgment. My lord, kindly note here, my lord, and park that contention, my lord, for a subsequent thing. Two things. If he grants assent, can it be subject to the challenge? If he refuses to grant assent, both, my lord, were immune from the judicial review. Now, draft constitution, my lord, prepared by the constitutional advisor, Mr. Rao. There shall be a council of ministers with the prime minister at the head to aid and advise. My lord, even the provinces had prime minister. My lord, this, when we use prime minister, it was present day chief minister. There shall be council of ministers with the prime minister at the head to aid and advise the governor in exercise of his functions, except in so far as he is by or under this constitution required to exercise his functions or any of them in his discretion. If any question arises whether any matter is or so and so, my lord, same that should not be called in question. Now, my lord, the draft prepared by the drafting committee. There shall be a council of ministers with the chief minister. Now, prime minister becomes the chief minister, my lord. Only nomenclature changes, my lord. Because there was no prime minister in 1935, the governor general was the whole and all, my lord, answerable to the crown. Chief minister at the head to aid and advise the governor in exercise of his functions, except in so far as he is by or under the constitution required to exercise his functions or any of them in his discretion. If any question arises whether any matter is or is not a matter as respect, my lord, same. Whether he exercises his discretion rightly, wrongly cannot be gone into. That is, my lord. Now I come to, my lord, the Constituent Assembly debate on this. And thereafter, my lord, the last debate I will read would be Article 200 and 201. Thereafter, my lord, the submissions start, but your lordships must have, my lord, the background in which these provisions were drafted and formulated, the manner in which they were formulated. What was conceived? My lord, H.V. Kamath. Mr. President, sir, I move that in clause 1 of Article 143, the words, except in so far as he is by or under this constitution required to exercise his function or any of them in his discretion, be deleted. My lord, Mr. H.V. Kamath has always supported the provincial supremacy over central supremacy. He was proponent of that. He may have some personal equations also, my lord, and he always used to object. But this was his, my lord, idea of the constitution. if this amendment was accepted,
Influenced by the American system.
highly influenced, my lord, by the Americans, because some of, my lord, that tendency and trait, my lord, continues even till date. We still believe in the American Constitution and apply it, my lord, in the context of Indian Constitution also. And that, my lord, sometimes results into laying down the law, my lord, which creates more complications than solving them. Sir, it appears from the reading of this clause that the Government of India Act 1935 has been copied more or less blindly without mature consideration. Well, this is kind of a personal affront to Dr. Ambedkar, that you have copied something without applying your mind. There is no strong or valid reason for giving the governor more authority, either in his discretion or otherwise, vis-a-vis his ministers, than has been given to the president in relation to his ministers. If we turn to Article 61(1), we find it reads as follows: there shall be a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of his function. When you, sir, raised a very important issue the other day, Dr. Ambedkar clarified that his clause by saying that the president is bound to accept the advice of his ministers in the exercise of all his functions. But here, Article 143 vests certain discretionary powers in the governor, and to me it seems that even as it was bad enough. But now, after having amended Article 131 regarding election of the governor and accepted nominated governors, it would be wrong in principle and contrary to the tenets and principles of constitutional government which you are going to build in this country. It would be wrong, I say, to vest governor with these additional powers, namely powers. I feel that no departure from the principle of constitutional my apology.
That's emergency.
Emergency.
Operation of
But,
emergency.
one interesting thing, my lord, an unfortunate thing. When 356 was being drafted by the Constituent Assembly, Mr. Kamath again, my lord, objected to that central government cannot be conferred power.
So Kamath was not in the drafting committee.
No, in the
When
Constituent.
when it was debated in the Constitution.
Yeah, when it was debated in the Constitution, he objected that central government should not have the power to impose precedence rule, and therefore Article 356 should not be there. To salvage the situation, my lord, it seems, Dr. Ambedkar ji says very wisely that I hope and trust that this article would remain a dead letter in the Constitution.
Yes, that's in his speech of 3rd of November 19.
3rd of November, your lordships are right. Your lordship remembers the dates also, my lord, correctly. I am grateful. Now, my lord,
Student of law.
my lord, we are all students of law. My lord, unfortunately, in the first government which was formed after the first election under Pandit Nehruji, Lord, the first 356 use came in Kerala state. Nambudripad was the popular leader and he was unseated under Article 356. I'm not going into the politics of it. But that debate was going on, my lord, in the parliament, and debate was whether it should be exercised or not. And Mr. Kamath, my lord, made one comment which, my lord, I think he should have avoided. He said that when the constitution was being debated in the Constituent Assembly, Dr. Ambedkar said that this article would remain a dead letter word in the constitution. Today, Dr. Ambedkar is dead, but the constitutional provision remains and it is being operated. So possibly he had some personal, my lord, equations. But be that as it may, my lord, we are not concerned with it.
One is entitled to have his own view.
No view, my lord, certainly.
He might be having a view that why should an elected government in a province
Should be
should be
dislodged.
under the control of the central government through the governors.
No, he always, my lord, he was an absolute provincialist, that it should be completely immune from any central interference. All his, my lord, objections are leading to that provinces should be completely independent and like American model. My lord, he was genuinely, maybe as a theory.
Everybody was, we have the constitution recently consisting of so many people having so many ideas.
Ideas, my lord, and Mr. Kamath was a former ICS officer, resigned and started participating in freedom struggle, and he had contributed a lot, my lord, and he, on his own right, my lord, elected to Lok Sabha. So he was not just a, my lord, troublemaker. He had a very strong view, and maybe some, my lord, we all have, my lord, likes and dislikes. I see no harm in the
On
provision.
Mondays and Fridays, we have 17 Supreme Courts.
Lord, if I may say on a lighter side, my lord, 32.
No.
No, that's not true.
On the lighter side. I see no harm in the provisions in this article being as it is.
Yes.
If it happens that this House decides that in all the subsequent articles, the discretionary power should not be there, as it may conceivably do, this particular provision will be of no use and will fall into desuetude. The point that my honorable friends is trying to, my lord, he ultimately says that let us wait till the actual conferment of powers in the respective spheres comes. Therefore, the serious objection of Mr. Kamath finds for mention of this exception is pointless. I therefore think that the article had better be passed without any amendment. If it is necessary for the House either to limit the discretionary power of the governor or completely to do away with it, it could be done in the article that occurs subsequently, where specific mention is made, without which this power that is mentioned here cannot at all be exercised. That is the point I would like to draw the attention of the House to, and I think the article can better be passed as it is. Then Dr. P.S. Deshmukh. Mr. President, Mr. Krishnamachari has clarified the position with regard to this exception, which has been added to clause 1 of Article 143. If the governor is, in fact, going to have a discretionary power, then it is necessary that this clause, which Mr. Kamath seeks to omit, must remain. So first you decide whether he should have discretion or not. What discretion we will define when we deal with other articles. Sir, besides this, I do not know if the drafting committee has deliberately omitted or they are going to provide it at a later stage. And I would like to ask Dr. Ambedkar whether it is not necessary to provide for the governor to preside at the meeting. That may not be relevant. My lord, kindly turn the page over. Sri Alladi Krishnaswamy Iyer. Sir, there is really no difference between those who oppose and those who approve the amendment. In the first place, the general principle is laid down in Article 143, namely the principle of ministerial responsibility, that the governor in various spheres of executive activity should act on the advice of his ministers. Then the article goes on to provide, except in so far as he is by or under this constitution required to exercise his functions or any of them in his discretion, so long as there are articles in the constitution which enable the governor to act in his discretion, and in certain circumstances it may be to override the cabinet or to refer to the president, this article as it is framed is perfectly in order. if later on the House comes to the conclusion that those articles which enable the governor to act in his discretion in specific cases should be deleted, it would be open to revise this article. But so long as there are later articles which permit the governor to act in his discretion and not on ministerial responsibility, the article is as drafted is perfectly in order. The only other question is whether first to make a provision, your lordships can skip. Now please come to the bottom. Dr. Ambedkar, my lord, replies, Mr. President, sir, I did not think that it would have been necessary for me to speak and take part in this debate after what my friend Mr. T.T. Krishnamachari had said on this amendment of Mr. Kamath. But as my friend Pandit Kunzuru pointedly asked me the question and demanded a reply, I thought that out of courtesy, I should say a few words. Sir, the main and the crucial question is, should the governor have discretionary powers? It is that question which is the main and the principal question. After we come to some decision on this question, the other question whether the words used in the last part of clause 1 of article 143, that is present 163, should be retained in that article or should be transferred somewhere else, could be usefully considered. The first thing, therefore, that I propose to do is to devote myself to this question, which, as I said, is the crucial question. It has been said in the course of the debate that the retention of discretionary power in the governor is contrary to responsible government in the provinces. It has also been said that retention of discretionary power in the governor smells of the Government of India Act 1935, which is the main was undemocratic. Now, speaking for myself, I have no doubt in my mind that retention on the vesting of governor with certain discretionary power is in no sense contrary to or in no sense a negation of responsible government. I do not wish to rake up the point because on this point I can very well satisfy the House by reference to provisions in the Constitution of Canada and Constitution of Australia. I do not think anybody in this House would dispute that the Canadian system of government is not fully responsible system of government, nor will anybody in this House challenge that Australian government is not a responsible form of government. Having said that, I would like to read section 55 of the Canadian Constitution. Article 55, where a bill passed by the House of Parliament is presented to the Governor General for the Queen's assent, he shall, according to his discretion and subject to provisions of this Act, either assent thereto in the Queen's name or withhold the Queen's assent or reserve the bill for signification of the Queen's pleasure. Three options. Pandit Hridaynath Kunzuru, may I ask Dr. Ambedkar, when the British North America Act was passed, Dr. this was kindly a sarcastic question, it seems. The Honorable Dr. Ambedkar, that does not matter at all. The date of the act does not matter. I mean, nearly a century ago. Dr. Mr. Kaman says that you are referring to
only wherever in a subsequent article discretion is provided.
Yes, madam.
In those articles, in the discharge of those functions, only he can exercise his discretion and not otherwise.
No, otherwise, my lord, by aid and advice.
Clarified, where he says, therefore, Article 143 will have to be read in conjunction with some other articles
Which specifically
reserve the
reserve-
power to the governor.
Yes.
It is not a general clause giving the governor power to disregard the advice of the ministers in any matter in which he find he ought to.
What are the provisions that this Constituent Assembly proposes to make with regard to vesting of the governor with discretionary power? My difficulty is that we have not yet come either to Article 175 or 188, nor have we exhausted all possibilities of other provisions being made, vesting the governor with discretionary power. If I knew that, I would very readily agree to amend Article 143 and to mention the specific article, but that cannot be done now. Therefore, my submission is that no wrong could be done if the words as they stand in the Article 143 remains as they are, they are certainly not inconsistent. Conferment of discretion.
Is there a revisitation of this debate after the debate of 175 and 188?
No,
Yes.
No, there isn't.
Yeah, yes.
It's not there.
There isn't.
Lord,
So
in-
at that time, we didn't have anything like
Lord, in when
impact assessment of a statute. Or as of now,
Your
if
Lordship.
we see the amount of litigation it has thrown by having provisions of this nature, perhaps that could tell us whether the vision was right or not right. Because the validity or correctness of a thought would come by its performance.
how it
End of
operates.
today, experience.
How it operates,
Of
how
today,
it has
the amount of
operated.
litigation it would have thrown, which could perhaps be
My lord,
avoided.
I
with
may make
certainty and
one-
clarity.
Lord, I may make one thing clear. While reading this debate, my lord, it is not my intention to argue and ultimately, my lord, that governor has absolute discretion. That's not the purpose of reading this. The
You know,
purpose.
that under this article, the power of the governor to exercise his discretion, wherever the subsequent articles reserve the discretion in him, the governor would be entitled to exercise the discretion, and Article 200 is one of such articles where a discretion is provided to the governor.
My lord, by very nature of the article, it is so provided, and I'll, my lord, come to that. And when I read, my lord, Article 200 debates, my lord, that comes out because, my lord, there are as my lord Justice Nasima rightly says, we understand the constitutional principles based upon how it has operated, how it has worked. My lord, there are some conventions which are also developed. For example, my lord, 163 says that the governor will act on the aid and advice of the Council of Ministers. Now, my lord, when the first person is to be called to form the government, there is no Council of Ministers. So the governor, by very nature of the act, will have to act on his discretion. My lord, when there is a dispute, which leader has the majority in the house?
We have some experience as to in what manner some of the honorable governors have exercised their discretions, leading to so many litigations.
My lord, I must, my lord, tell your lordships and my lord, put a little word of caution for myself also. My lord, if we go by some example,
We are not going by that.
I understand. No, I am saying something else. Lord, Indian democracy is a mature democracy. There may be aberrations, my lord, on individual cases. But by and large, the democracy under this very constitution has worked very effectively. And that, my lord, I have personally witnessed, my lord, during COVID period. During COVID period, my lord, the Indian democracy and how the center, province, federal balance is envisaged what was at display. Lord, party in power in the center, which was Lord NDA, BJP, etc. All state governments ruled by Congress, ruled by communist, everyone, they were on the same page with the Honorable Prime Minister. There was no dispute, difference, and they used to call each other. That's the way democracy works. That you have debate, you have deliberation, you have consultation, you give suggestions, you take suggestions, and everyone was on the same page. My lord, since I was appearing, my lords, I know it for sure that chief ministers of those states whose chief ministers were very critical, and it was their right to be critical of the center. My lord, they used to call the prime minister at 2 o'clock that this is what we are needing, and there would be a serious problem, and the thing would reach. And my lord, the counter thing also. The government also responded in a matured way, except, my lord, one or two exceptional states. But everyone, my lord, because all these people, my lord, irrespective of the political leanings, they have, my lord, political experience of 30, 40, 50 years. They have that political maturity, my lord, to decide. So, my lord, it would be really hazardous, my lord, to even examine based on certain aberrations. There are ambitions, there are, my lord, pitfalls, but that is to be taken care of on a case-to-case basis. One cannot interpret the constitution based on the worst cause. Lord, hard cases always results into laying down of bad laws. That's, my lord, that's a settled principle throughout all jurisdictions.
If not otherwise, hard cases make good law.
But I would not respond to this. Then Dr. Ambedkar. Of course, there is, because we do not want to waste the precedent with any discretionary power. The provincial governments are required to work in subordination to the central government. And therefore, in order to see that they do act in subordination to the central government, the governor will reserve certain things in order to give the president the opportunity to see that the rules under which the provincial governments are supposed to act according to the constitution or in subordination to the central government are observed. Please mark this, my lord. This is, my lord, the fundamental foundation of, my lord, the Constituent Assembly. And this is what was the thought, the principle of constitutionalism in the mind of Dr. Ambedkar, that they must be free to take some level of, Lord, deference to the central government, because we have a quasi-federal constitution. Then H.V. Kamath, will it not be better to specify certain articles in the constitution with, my lord, he continues, my lord, with his objection, my lord. I may skip that. Now, my lord, kindly come to present, my lord. Green is Article 163, which is at present, that normally the governor will act in accordance with the aid and advice of the Council of Ministers, and governor must do it. We are not arguing A versus B. I am assisting the court because we are seeking your lordship's opinion. So I am just giving what is my reading of the constitution. Governor will have to act on the aid and advice except where he is having discretion, either conferred by the constitutional provisions or by the very nature of the power which he is exercising. Then, my lord, 200 and 201, and this is the last provision which I will bother your lordships with the Constituent Assembly debates, my lord, and then I'll come to other submissions, my lord. Please see 1919. This is very relevant because this is directly in question. This is precursor to Article 200. What are the options available for the governor when a bill is presented to him? Is he supposed to sign it as an automated person, as, my lord, one word which is
The postman.
He's not a postman. That's what, my lord, my effort would be, and that comes out from the constituent debate. The very nature, in the very manner in which Article 200 is couched, the language which is used, it gives him options. And when I am given 3 options, means I have been given discretion to choose one of them. The word discretion being used or not used will make no consequence if I am given 3 options or 4 options. I'll show that, my lord. Please come to, my lord, Section 12 of Government of India Act 1919. And this would be, my lord, relevant, directly relevant for the present purpose. Where a bill has been passed by a local legislative council, the governor, lieutenant governor, or chief commissioner may, instead of declaring that he assents to, or first option, my lord, is granting assent, assents to, or withholds his assent from the bill. Second option, return the bill to the council for reconsideration. Third option, either in whole or in part, together with any amendments which he may recommend, or in cases prescribed by rules under the Principal Act may, and if the rules so require, shall reserve the bill for consideration of the Governor General. That is precedent. So 4 options: assent, withhold, return to the House, or refer it to the Governor General, which is the present day President, for his assent. Where a bill is reserved for the consideration of the Governor General, the following provisions shall apply when it goes to the President in the present terminology. The Governor, Lieutenant Governor, or Chief Commissioner may, at any time within 6 months from the date of reservation of the bill, with the consent of the Governor General, return the bill for further consideration by the Council with a recommendation that the Council shall consider amendments thereto. The President can refer it back. Instead of the Governor choosing, Governor may choose that I will send it to Governor General, then namely the President. He can say that no, I send it back. B. After any bill so returned has been further considered by the Council, together with any recommendations made by the Governor, Lieutenant Governor, or Chief Commissioner relating thereto, the bill, if reaffirmed with or without amendment, may be again presented to the Governor, Lieutenant Governor, or Chief Commissioner. Any bill reserved for the consideration of the Governor General shall, if assented to by the Governor General within a period, time limit was prescribed by the Act itself for the President equivalent, namely the Governor General, to act. And I'll come to Malod that as soon as possible part. That is also Malod taken care of. From the date of such reservation become law on due publication of such assent, in the same way as a bill assented to by the Governor, Lieutenant Governor, or the Chief Commissioner, but if not assented to by the Governor General within such period of 6 months, shall lapse. Consequence also provided, time limit stipulated, and consequence provided, meaning thereby the time limit is mandatory, not discretionary, and be of no effect unless before expiration of that period, either 1, the bill has been returned by the Governor, Lieutenant Governor, or Chief Commissioner for further consideration by the Council, or in the case of the Council not being in session, a notification has been published of an intention so to return the bill at the commencement of the session. The Governor General may, except where the bill has been reserved for his consideration, instead of assenting to or withholding his assent from any act passed by local legislature, declare that he reserves the act for the signification of his majesty's pleasure. Well, this was a standalone provision because there was someone above the Governor General, the present day President. Here, President is
There's no one above.
no one above. Assenting to withhold, therefore, and I would come to that, my interpretation of the term withhold is that it is not given effect to it falls through. That's how the Supreme Court has read. Falls through. And please, read these provisions in this context. Now, 13. Provision for case of failure to pass legislation in Governor's Legislative Council. Where a Governor's Legislative Council has refused leave to introduce or has failed to pass in a form recommended by the Governor any bill relating to a reserved subject, that is state list, the Governor may certify that the passage of the bill is essential for the discharge of his responsibility for the subject, and thereupon the bill shall, notwithstanding that the Council have not considered thereto, be deemed to have passed. There is a deeming provision made by way of a statute. Deeming provision of a bill having been passed can be made either by a statute or by amendment of the Constitution. I'll come to that little later, whether that can be done by a judicial verdict, that's a separate argument. And shall, on signature by the Governor, become an act of the local legislature in the form of the bill as originally introduced or proposed to be introduced in the Council, etc. Rest of them may not assist your lordships. Please come to para 72 is the draft bill of the constitutional advisor, and kindly come to first 70 assent. This is again 1935 Act. what I read was 1919 Act, now 1935 Act. A bill which has been passed by the Provincial Legislative Assembly, that is present day State Assembly, or in case of a province having a legislative council, has been passed by both chambers of the provincial legislature, shall be presented to the governor, and the governor, in his discretion, my lord, the other side would harp upon this, that there was a discretion which now no longer exists in Article 200. Therefore, I am highlighting, my lord. In his discretion, shall declare either that one, he assents in his majesty's name to the bill, second, or that he withholds assent therefrom, third, or that he reserves the bill for consideration of the governor general, that is, my lord president, provided that the governor may, in his discretion, return the bill. This is the fourth option. Return the bill together with a message requesting that the chamber or chambers will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendment as he may recommend in his message. And when a bill is so returned, the chamber of chambers shall consider it accordingly. It stopped here. So three options, he can straightway say, I withhold, I grant assent. He can say, I withhold the assent, meaning thereby I will show the bill falls through. Third, he may say that no, there is some repugnancy, some violation of fundamental rights, I refer it to the president. And fourth option, in his discretion, he can say that no, it is curable defect in the bill, and therefore I return it with my message that this particular provision is repugnant. There is already a central law occupying the field, and therefore you please reconsider. Or even desirability, that instead of 19 years of age, you consider 21 or any such thing, my lord. I'm just not giving hypothetical examples. But four options were available to the governor then. Now, my lord, draft constitution, para 72, when Mr. B.N. Rao, Dr. B.N. Rao, my lord, prepared the draft constitution. A bill which has been passed by the provincial legislative assembly, or in case of a province having the legislative council, has been passed by both houses of the provincial legislature, shall be presented to the governor, and the governor shall declare either that he assents to the bill, one. Yes. 356 doesn't use the word discussion. Yes. But I was reading 147 as suggested by by the constitutional advisor. A bill which has been passed by the provincial legislative assembly, or in case of a province having legislative council, has been passed by both houses of provincial legislature, shall be presented to the governor, and the governor shall declare either, first option, he assents to the bill, or second option, that he withholds assent therefrom, third option, that he reserves the bill for consideration of the president, provided that where there is only one house of legislature of a province and the bill has been passed by both the houses of the houses, the governor may, in his discretion, it was initially there, in his discretion, return the bill together with a message requesting that the House will consider the desirability of introducing, I'm not reading it, it's the same,
Almost same.
except there is no consequence provided. If the House returns it back, now it says, governor shall not withhold. It comes, my lord, subsequently. Now, my lord, the committee, drafting committee,
So, in effect, if on the second occasion, the legislature again reiterates, then the governor will not have any option but to give it access.
not at this stage.
No.
No, I'm sorry. It was there. The governor shall not withhold SL therefrom. He has no option.
So it is quite in the negative.
Yes.
It gives a mandate that if it is passed,
You have to grant assent.
like the collegium,
That could have been used, my lord. That's a separate argument. I'm sorry, my lord.
like the collegium. Fortunately, we are not on that issue now. So,
Taken the same language.
I cannot say anything.
no, we are not on that issue. Let us stick to the case before us.
Now, my lord, please come to, my lord, now draft prepared by the drafting committee at page 145. The same. No real change, your lordship can take it from me. My lord, the drafting committee also goes this way, my lord. Then, in the draft constitution prepared by the drafting committee, now 201. Your lordships have
125 and 176.
the 200 and 201 present. That is, my lord, the subject matter of, my lord, the reference and your lordship's advice. 201, my lord, was drafted by drafting committee like this. When a bill is reserved by a
So
governor
earlier, there was only one section, now it is bifurcated into two sections.
into two sections. Because now we have a president and president has a different regime where he is bound by the aid and advice. He does not have, my lord, the choice, etc. I'll come to that. Please have a look. When a bill is reserved by a governor for consideration of the president shall declare either that he assents to the bill or that he withholds assent therefrom. Two options. Third option, provided that where the bill is not a money bill, the president may direct the governor to return the bill to the House, or as the case may be, the houses of the legislature of the state, together with such a message as is mentioned in the proviso to the last preceding article, and when a bill is so returned, the House or houses shall reconsider it accordingly. Please mark this, my lord, within a period of 6 months. This continues. Whenever Constitution intended to provide for a timeline, the Constitution has provided for. This continues even in the present Article 201. And therefore, it is not permissible to lay down any timeline in other articles. I'll come to that. That's a separate point, my lord. Now, my lord, the debate. This debate, my lord, both of us would be relying upon. The other side would also, in fact, there cannot be any other side when it is a presidential reference. But, my lord, the other side point of view, my lord, they would also...
Other point of view.
Other point of view, my lords. They would also rely upon to say that the discretion was taken away. My lord, apropos, my lord, Justice Narsimha's question, whether subsequent debates throw any light on that discretion or not. Because Dr. Ambedkar says that whenever...
That was not what my learned brother pointed out. That after the subsequent articles were discussed, like 200 and 201, wherein discussion was provided, was there a relook on the earlier article which provided for discussion?
No, there was none, but it comes in 200. Because
Because when D.T. Krishnamachari and both Dr. Ambedkar, they say that if in subsequent articles, if we do not provide for discussion, then we may have a look at this article.
We will see, because the wording says, my difficulty is that, I'm quoting from his state.
I do not know what
Difficulty
will,
is that we have not as yet come either to Article 175 or 188, nor have we exhausted all the possibilities of other provisions being made, vesting the governor with the discretionary power. He said as and when. We'll see at 200. In all
yeah,
cases.
your lordships are right. My lord, that one Article 175 debate is,
It was not necessary because in the subsequent articles, they provided for discretion. So there was no question of
Absolutely.
again having a relook at.
but my lord, this is the debate. Page 146 is that debate which my lords were referring to. But, my lord, please bear in mind that in 163, the discretion remained that aid and advice except subject to, my lord, by or under the constitution. And I may tell your lordships, subsequently, there are no articles which specifically uses the word discretion. Subsequent to Article 163, there are no articles which confers discretion. But after reading this, my lord, debate, my submission for your lordship's consideration is going to be that if the article itself gives him options to choose from, use or not use of the word discretion does not matter, because he is that you choose from either of these four.
Then the discretion has to be exercised among the options given in that article.
Lord, I'll come to that. I'll come to that.
If the article provides for 4 options,
Yes.
then the discretion would be restricted to only one of those 4 options.
Correct. I bow down. It cannot be beyond that. Governor is bound by one of those 4 options. Governor is bound by one of those 4 options. But which option to choose from,
It is discretion.
it is his discretion. Lord, for example, for the purpose of granting assent, the Council of Ministers would always say that grant assent, it is our bill. So there is no question of, my lord, he is using discretion.
That will be relatable only to that part of the question where it is sent back to the assembly for reconsideration. And it is coming back to him. At that second stage, will he
No
be
discretion.
entitled to send it back to the president for his approval?
There he would have the
This
discretion.
is where you are talking about.
That is there, he would have the discretion. He cannot withhold it.
That's your argument.
But, yes, that's my argument. My lord, but the problem has arisen because of state of Punjab judgment. Not the state of Punjab judgment. I'll come to that, my lord.
But the issue relating to timelines is not relatable to the options.
No. That's a separate point. That's a separate. Your lordships are right. Timeline has nothing to do with the option or discretion, etc. Since I was there, since I was showing the provision where the Constitution itself prescribed time limit, since I was reading the provision which itself provided for time limit, I just as a reference said that whenever the makers wanted, they have provided for the time limit. And if it is required, it can be done by constitutional.
Timeline which you are referring to is for reconsideration by the legislature.
Legislative time.
That is not a
Not the
timeline given
executive
for
time.
the governor.
Exactly. That's my case. That's my case. That now you are reading something which the Constitution has provided, not provided.
So ultimately, probably, Mr. Solicitor, possibly there can't be any serious dispute with regard to the 3 or 4 expressions used in 200. Assent, shall declare, assent, or withhold, send send to the president for advice. And third is that may return. But the word in his discretion has been omitted on the suggestion of Dr. Ambedkar. Earlier the draft was
Bound.
his discretion.
Your lordship, absolutely.
Dr. Ambedkar advised that no, we should delete these words. Those were deleted.
Yes.
So these are the options available. Probably the central point of debate will be, what do you mean by withhold?
I'm grateful.
That will be the central point.
I'm
Is it withhold means that after withholding it means that you are not assenting and you are for the time being withholding yourself. Withholding for what? Either to return to the assembly for reconsideration with your message or advice,
Punjab judgment says.
or you send to the president. For example, there may be a draft bill touching upon or encroaching upon the power of the parliament under list 1. Governor is well within his right to say, state assembly can't pass it, so therefore he can either advise them that look here, you need to look into it, you can't encroach upon list one, this is not within your domain. Or he will send to the President of India saying, the state has attempted, the state legislature has attempted like this. In my considered opinion, this such a bill will fall under entry number so and so, for which state legislature is incompetent. And Honorable President will take the final call on that. The
Lord-
only issue will be this one. Probably
Yes,
it's
yes.
not
Lord, only issue will be, and I'll come to that after reading this.
how much time now this entire process should be undertaken. That is probably central point.
The time for completing the process. I'll come to
Form an
that.
opinion.
I'll come to, but that's a separate, my lord, argument.
But
Please
we-
allow me, my lord, but since your lordships have given a very right and apt example, the withhold, my lord, whether withhold is a temporary act of withholding, or as the Supreme Court through 5 judge and 7 judge benches have said, that withhold means the bill falls through. Because there are circumstances where, suppose, my lord, normally the legislature is not expected or is not supposed to pass egregious, my lord, something, my lord, a very extraordinary bills which are beyond their competence. But suppose, my lord, how we read the Article 200. My lord, suppose a border state passes an legislation which deals with our external affairs, that will permit a particular country's people to enter or not to enter.
You
What?
can respond to these.
Give me a minute.
As per the way you want. You are only pointing out that rest of the this discussion ultimately leads to the final bill at page 150, and probably thereafter this issue arises.
Your lordships are right. My lord, then he cannot assent. He cannot refer it to the president because it's not a repugnancy issue. He cannot return it to the house, because once he returns it to the house and house repasses it, then he is bound, he cannot withhold it. Then he will have to withhold, my lord. And I have given the examples. It is to be used rarely, sparingly. But that's the way the situation is.
Sorry, what is your submission?
Lord, there can be instances.
There are 4 instances, 4 options. Either he assents to the bill or withholds assent therefrom, and that he reserves the bill for the consideration of the president. So according to you, the withholding of the assent, the second option, can be unlimited.
It's not, my lord, a temporary withholding. My lord, can I go, my lord, a little, my lord, in the chronology so that I can make that point good? Yes, my lord, my answer is yes. That withhold means the bill falls through. That's how, my lord, the 5 judge bench and 7 judge benches have understood, my lord, this Article 200. And I have given examples.
But then, if he doesn't, if he doesn't exercise the option of resending the bill for reconsideration to the governor, still he can withhold it for a time immemorial.
It dies. It dies. It is to be used rarely, but the power is conferred. My lord, rather than, my lord, entering into this debate right now, can I, my lord, just give the background?
Like for example, in the Tamil Nadu case, 10 out of 12 bills after the first consultation, he said, I am withholding these 10. But you are not talking about a situation where he would communicate saying that I have
It's a declaration.
It is not necessary for him to exercise the purse under the proviso. He may bypass the proviso and still hold that.
Therefore, I am requesting your lordships to park that question right now. That's not my case. That's not my case. That's the extreme case visualized in Tamil Nadu, and whether we like it or not, we are burdened with the Tamil Nadu facts. I am arguing dehorse Tamil